if you thought the case involving the 14th Amendment, Section 3 could get complicated, when you come down to presidential immunity, and how about this? Post-presidential immunity, which is what we're looking at what is at the Supreme Court now. So you've got the filing by President Trump and their team. That then has now been scheduled to the reply. The response has been requested by the Chief Justice a week from today on February 20th. And again, in between now and then, that's stayed, so nothing's going to change on that immunity case. It's not going to move forward.
Effectively, you got to stay pending the next disposition
of the court.
Narrow,
very short.
I don't think maybe he will take all the way to next week, but what the order says is the response to the application, it now has a number, 23A745A, meaning application, requested by the Chief Justice, due February 20th, 2024 by 4 p.m. That will be, Andy, the government's response.
That's right. The government will now have, based on what the Chief Justice has decided, till February 2024 to respond to what has been termed an application for a stay of the D.C. Circuit's mandate, which was the order to Judge Chutkan to do what we tell you to do, but they stayed it, pending the filing of a petition for writ of certiorari.
But you know what they're going to come back and say. They're going to come back and say, hey, the D.C. Circuit got it right. That's what they're going to say.
Well, I don't know. I think it's a case
that's what Jack Smith's going to say.
Of course, Jack Smith is going to say that I was right in the D.C. Circuit and I should prevail in the Supreme Court if you take the case on the merits. But, of course, what the president is saying is that unless you take it, the president would face the threat of indictment by an opposing party after changing administrations. I'm reading from the brief.
Here's the contra argument. Here's what some lawyers, appellate lawyers, are saying, and this is where it gets a little confusing, but I think people need to understand. Some lawyers are saying the case should go to trial. The facts should be put forward as to what he actually is accused of doing, what acts he took. There'll be a trial. There'll be an adjudication of guilt or innocence. Then it would go to the Court of Appeals to determine whether the immunity question should have been addressed with official acts or not, and then to the Supreme Court. The problem is the taint that puts on the candidate running for office.
Well, yes.
And also the timing of this could get very difficult.
The timing of it, and if you got to look at the U.S. Attorney's Manual, and there's a memo that was put out in 2008 by the Justice Department called Election Year Sensitivities, and it's from the Attorney General, and it says you got to be careful, Justice Department, that you don't do criminal prosecutions for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. If you look at the U.S. Attorney Manual, that specifies it not within 90 days of an election.
So the election is November 5th. So you'd go back October 5th, then you'd go back to August 5th, then you go back September 5th. If the trial did not start until July, which is now they're saying the earliest it could because March is off, it would go all of July and all of August. Boy, you are right up to that, right up to it. What do you think happened? What do you think Judge Chutkan does?
I think Judge Chutkan does not try this case.
I don't either. Unless it's all dismissed, unless they deny. Because here's what they could do. I mean, we're kind of talking out loud, Jordan. They could turn this application for a stay into a certiorari petition.
Correct.
Meaning they could say, you don't have to file a certiorari petition. We're going to look at the application for a stay, which lays out the legal issues, and that's your certiorari petition, and then grant or deny it very quickly.
So, I mean, it could this can move very fast.
Yeah.
I don't see it moving very slow because the justices know people are voting. I think President Trump, the ability to campaign would be impacted by this, as we were just talking about by Andy. And then but people probably are not understanding this idea. So they could file for a stay and they could turn the stay into a certiorari grant that would necessarily mean that they could make an opinion with or without an oral argument.
Correct.
Would they order more briefing?
They may order an additional round of merits briefing,
but not necessarily.
But I think they would, and I think now there's another thing that can happen here, and I think it's 50-50. They could just deny review.
And if they deny review,
it goes right back to Judge Chutkan. She sets it up for a trial calendar.
And President Trump is being tried.
I think then
he's
tried.
criminal.
Then I think he would be tried before the election. If
it
was in the next week or two.
Although Judge Chutkan has been very, very sensitive to this political process that is ongoing collateral to her criminal case.
We're talking out loud here, but if it was February and they turn it down next week, Supreme Court says I'm not going to hear it. It returns to her.
It does return to her.
Okay, so she says I'm not going to do it in March, but why can't I do it in May or June?
No, she could. There's no doubt about it. I just don't think that she would do that.
I think she would if it's outside the 90 days. I don't think it could go past the start of a June 1st start.
Could be.
I think that's we're talking out loud here because we are really in
very much so.
uncharted territory. And then the question is, I want to hear from our audience on this. How does that impact how you would vote if there was a conviction? If you're for Donald Trump, but there was actually a conviction, does it change anything? Because the polls say it does. Yeah. There's a 6 to 7% change. I'm not sure that's real.
All right. Hey, Lynn, welcome to Seculo. You're on the air.
Yes, thank you for taking my call. If it were up to me to be a juror and make a decision on that, I would have to say that President Trump was still sitting president in office on January 6th because the incoming president had not yet taken his oath of office nor signed in as president in seat as chief, because if there were a state emergency, President Trump during that period...
That's correct. There was no question that when the president made the statements he made and took the actions he took, Andy, he was the president of the United States.
Absolutely.
The question is, and there's not been an adjudication of this, is were those official acts? And I would say elections go to the core of official acts in the sense of faithfully executing the laws, which is a mandate from the Constitution to the chief executive president of the United States.
I think that's exactly right. The president was doing what a president can do and seeing that the laws be faithfully executed as he saw that being done and as he saw fit.
But there was there's been no adjudication of that so far. No one has determined that these are official. Well, I mean, the D.C. Circuit basically said they weren't, and the immunity didn't apply. But the D.C. Circuit said the immunity stopped applying, if at all, on December 20th at 12:01. On January 20th, 12:01.
For anything that happened during the presidency.
That is wrong, and that would have been a question I would have put as one of the questions presented, but they didn't, and they've got their reason for doing it, but we'll see.
I mean, I think where it gets complicated by the U.S. Supreme Court is trying to define what is and what is not an official, like we talked about. What is an official act? It's not just about the timing of when you were in office. Sure, most of those acts would likely qualify as official, but you still are a human being. If you did something that was criminal outside of the official acts as president, what happens then? And then you're going to have the Supreme Court, defining official versus unofficial. Now you're talking about the peripheral official. I mean, that is exactly the kind of case the Supreme Court doesn't want to have to do, that kind of balancing test. They want to stay out of that. But, because of these prosecutions, it keeps landing at their doorstep on this immunity
they don't love
question.
Let me tell you.
And I think ultimately American voters have got to have an answer, which is, could they be voting for someone that could be convicted of serious enough crimes that they could win the election potentially, which would be, I think, tougher to win, but be behind bars?
Well, this is because if you're convicted, you could technically be sentenced to jail. Now, here's the thing. Under the procedure that's been outlined so far, remember, they're just asking for a stay, and they want to go back to the D.C. Court of Appeals for en banc review. That means all of I think it's 11 sitting justices. Whether they get it or not, we'll see.
Why did that happen? What was it? What was the jump here? Was that Jack Smith?
No, it was Jack Smith did it the first time. Jack Smith said, hey, go right to the Supreme Court, and the Supreme Court said, no, let it go through the regular process. It was expedited at the D.C. Circuit, but the D.C. Circuit, in this opinion, came out and said, we're going to send it back to the district court. So if you want to file a petition for en banc review, good luck, but it's going to trial, which was not the way. Or if you go to the Supreme Court, we'll stay everything until the Supreme Court disposes of it. The Supreme Court could grant review. They could say, hey, no, wait a minute. It should go back now to if they want to do en banc review, let them go to the whole court. I know this is complicated. I'm trying to break it down. But if you're the president, the goal is don't go to trial before the election. Politically, right? Yeah,
politically, again, because the conviction likelihood in a D.C. jury is so high of now criminal acts. These are not, again, this is not civil courts, but the criminal acts. And then you get the whole idea of, what happens. Again, limits your ability on the campaign trail. It kind of dogs you on the campaign trail. So you would likely want to go as far back as you can in restarting this case. And maybe that first step is then going back to the Court of Appeal, the full en banc panel of the Court of Appeals, and then back to a trial court to retry it once again. That's the real issue here.